Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officer, official, listener, learners, all my dear friends. I heartily, cordially welcome all respected doctors and directors. I welcome all available ministers and managers. I welcome all honorable advocates, referees, and administrative advisors. I welcome the most honorable present, Mr. Modi ji. It's really nice time, nice place, nice action today. We are describing international law and human rights. Some other theories regarding the basis of international law. Our holy Indian cultural, social, spiritual heritage features unite us in the form of diversity. It is the great feature of our nation since time immemorial. Naturally, it is written in all our holy scriptures of this holy band that we are known by equality, unity, oneness. There is no discrimination on the basis of caste, color, creed, and language. Our holy Indian constitution, its cultural identities, social, spiritual identities makes us one. Wherever, whenever we see around the world in our nation, we feel that nature nurtures us like a mother. Nature treats us like a doctor. Nature teaches us like a teacher. Nature plays multi-dimensional, multi-sided, multifaceted role. Nature never busy, meet, cheat, defeat us. That's why everyone loves nature. Nature has direct connectivity, relativity with Lord or God. Inside us, it is said in all human rights. In the view of the supporters of this theory, consent of states is the basis of international law. States observe rules of international law because they have given their consent for it. Positivists have given much support to this view. The chief exponents of this theory are Angelotti. This theory fails to explain the basis of customary international law. In the view of the supporters of this theory, States are bound to observe customary rules of international law because they have given their implied consent or their assent. This theory has been subjected to severe criticism by many jurists, such as Stark, Bradley, Kelson, Fenwick, etc. As pointed out by Stark, in practice it is not necessary to prove that the other state or states have given their consent in regard to a specific rule of international law. According to Professor Smith, all states are bound by international law, no matter whether they have given their consent or not. In regard to customary rules of international law, the basis of implied the basis of implied consent is far from correct. The states are bound by general international law even against their will. Professor Carlson has cited the example of new states which get rights and duties under international law. Immediately after regarding the subject of international law, in the view of Fenwick, the theory of consent is correct because it is against the principles and things which the states have been accepting since the beginning of international law. Theory of consent false. Theory of consent fails to explain the case of recognition of new state. The granting of recognition is the act of other states, and hence it would be wrong to say by getting recognition the recognized state has given its consent in respect of international law. According to Bradley, the theory of consent cannot explain the true basis of international law, even if we distort facts and try to fit them in the theory. Thus, we see theory of consent cannot explain the true basis of international law and can be severely criticized. As pointed out earlier, states has followed international law for the simple reason that they are states. As an ordinary person has to obey municipal law, even against his will. Similarly, states are bound to follow international law. To courts are caution first again, international law is, in fact, binding on states because they are states. Thus, consent can never be the ultimate force of legal obligation. However, as noted earlier, common consent can be said to be the basis of international law as a legal system in the sense that we see the basis of international law in the existence of an international community, the common consent of whose members is that there shall be a body of rules of law, international law to govern their conduct as members of that community. This common consent is not consent to particular rules but to express or tacit consent of states to the body of rules comprising international law as a whole at any particular time. Auto limitation theory. According to this theory, international law is binding upon states because they have restricted their powers through the process of auto limitation and have agreed to comply with international law. This theory is also based on the view of the positivist. This theory also based on the view of the positivist. This theory based great stress on independence and sovereignty of the states Gehring is the chief exponent of this theory. The basis of this theory is that each state has a will which is completely independent and free from external influences. But through the process of auto-limitation, states can restrict its powers and thereby limit its will. In short, states are bound to follow international law because they are independent and sovereign, but the states can make themselves bound by rules of international law by restricting its powers. This theory has also been subjected to severe criticism by the jurists. This theory is based upon a presumption that there exists a state will. In fact, the will of the state is nothing but the will of the people who compose it. Besides this, auto limitation is no limitation at all. The auto limitation theory will imply that the state can free itself from self imposed restriction at its will. In practice, this is not possible. Briefly, modern jurists have seriously criticized this theory. First, this theory is failed. Complete how it is known that states can only be bound by self-imposed obligation, or why this true or their validity should be accepted in advance of any examination of in the argument that this theory fails to explain the case of the new state. Here the attempt to rest the new state's international law obligation on a tacit or infunded by some other state which dealing with it. For the first time, the decisions of obligation under rules which previously it had no possibility either to observe or break, and to which it had no occasion to give or withhold consent. Pacta sunt servanda, pacta sunt servanda. In the view of Italian jurists and the laity, the binding force of international law is based on the supreme fundamental norm or principle known as pacta sunt servanda. This means it will be respected and followed by them in good faith. This is a well-established and recognized norm of international law. The customary definition of the binding force of international by states and regards them as the basis of international law. It cannot but be admitted that pacta sunt servanda is a very important principle of international law. States must respect the agreements entered into by them and follow the same in good faith. If it were not so, there would be anarchy and disorder in the international field. But to assert that the abiding force of international law based only on the principle of pacta sunt servanda is far from truth. It fails to explain the binding force of customary rules of international law, which are not based upon agreements between states. It has been rightly remarked the realization that international customary law does not rest on agreements and that the tenant pacta sunt servanda is itself a rule of customary law led to new formulation of the basic norm. Calston himself has decided on a formula which takes into account of usage as a fact which is the origin of the rules of international law. States ought to behave as they have customarily behaved. Theory of fundamental rights. This theory is based on the naturalistic viewpoint. According to this viewpoint, prior to the existence of state, man used to live in natural state and even in the state he possessed some fundamental rights such as independence, equality, right to self-preservation like man state also possessed these fundamental rights because so far there is no word or institution over and above the states. In its criticism, we can say this theory has been severely criticized by jurist J.L. Bradley. J.L. Bradley has made the following criticisms of the theory. One is, according to this theory, when a new state is admitted to the family of nations, it brings with it certain fundamental rights which are inherent. As a matter of fact, such rights are meaningless unless there is a legal system which confers validity on them. To which this theory cannot be commended because it is in favor of giving more freedom to the states and lays less emphasis on social relations and cooperation among the states. His last but not the least shortcoming of this theory is that it regards certain fundamental rights such as independence, equality, etc., as natural rights, but as a matter of fact, these fundamental rights are assumed as a result of historical development. New trends regarding basis of obligation in international law. Since the beginning of modern international law, consent has been the basis of obligation under the international law. Consent played such a prominent role that it was even extended to explain the basis of customary rules of international law. The positivists tried to establish that international customs were based on tacit agreements between states. The unanimity rule was the prevailing rule for every conference and treaty. Only a party to treaty was bound by it, though the unanimity rule still continued. The United Nations Charter introduced majority rule in all of its origins, in all its organs in the course of time. General Assembly gained strength and became the most potent organ of the UN. Though not originally ambitious, General Assembly even started legislative activities and passed a number of resolutions which were results of unanimity rule seems to be crumbling against the onslaught of majority rule in international organizations. This change has necessitated a change in the theory of obligation in international law. A unique feature of new international law is that it is found not only in the lawmaking conference but also in law creating conferences such as those of UNCTAD, UNCTAD, GATS, IBRD, ILD, OECD, OPEC, etc. It has been aptly pointed out the GA, that is General Assembly, resolution constituted the joint action and the process to which states and people pursue their objective. The point is, it would be naive to ignore such law-creating resolution. One may legitimately go a step further to state that given the current concerns of the world community and the vastly multitude of joint action being taken, lawmaking conventions and conferences are only tiny episodes in the drama of international law. Further, an international law would cease to have any validity or relevance if it did not take cognizance of the processes through which the world community pursued its pressing concerns. One more important change that has taken place is that many a decision at international conference and General Assembly of the UN are being adopted by consensus. Though the unanimity rule has not been completely defeated, the basis of obligation in international law is changing from sovereignty oriented consent to community oriented consensus. As Husserl has remarked, we must wait on the future to see whether the requirement of consent of states in international lawmaking can ever become independent of the treaty possession be satisfied by the vote in the General Assembly or an international conference convened by it. In the Law of Sea Convention at least, the treaty form has already begun to see a grumbling appendix. Further Resolution 1962 17, which decided legal principle on outer space, may fairly claim to have furthered the progressive development of international law called forth by Article 13.1 because it has formulated general principles of law of international conduct or authoritatively interpreted the United States 2749 25, which declare legal principles governing the seabed and ocean floor and subsoil thereof beyond the limits of national jurisdiction regarding such type of resolution. Empire has said that while it is unsafe to generalize upon them, there is no reason, there is no reason, there is no reason of principle why they should not establish obligation. They are much more than a program of desirable objectives. They are an attempt to deduce some of the implication for international law as regards Resolution 1962 18. Before the conclusion of Outer Space Treaty, Professor Jenks aptly remarked, the authority of the Declaration of Legal Principles may be expected to grow with the passage of years. While it is somewhat less than a treaty, it must already be regarded as rather more than a statement of custom. The International Court of Justice has also lent its support to the aforementioned change. For example, from sovereignty-oriented concern to community-oriented consensus in the basis of obligation in the international law. In the case concerning re-limitation of the word as a result of that conference, the Chamber notes in the first place that the convention adopted at the end of the conference has not yet come into force and a number of states are portions of the instrument and they all cannot invalidate the obligation that certain provisions of the convention concerning the continental shelf and the exclusive economic zone which may in fact be relevant to the present case were adopted without any obligation. In the Chamber's opinion, these provisions, even if in some respects they bear the mark of the compromise surrounding their adoption, may nevertheless be regarded as consent at consonant at present with Andalusian, Libya, Arab, Jumayyat, or Malta. Although the international actual practice, in opinion, juries of states, even though convention is of major overwhelming majority of states, and it is clearly the duty of the court, even independently of the relevance made to the convention by the party, to consider in what degree any of its oriented consensus or sovereignty oriented consensus. But the battle has not been finally won, and the struggle is likely to a prolonged one. As a matter of fact, consent will continue to be a basis of obligation, and there should be no objection to it. But in view of our widening scope of international law, it has become necessary to recognize the importance and utility of consent as a basis of obligation in international law. The theory of consent as a basis of obligation was given by the European states to humanity as a whole, and the changes that have taken place in each state age may take into account the interest and inspiration of international community as a whole. The International Royal Jellyfish can make a significant contribution in this direction in the absence of natural law. The origin of the origin of natural law can be traced to centuries before the birth of Christ. Probably no other principal or school of law took as much time in its development as the law of nature. Moreover, as aptly remarked by Daesh, further